is to represent the warden. These cases are actually, in most cases, filed against the warden. They're habeas corpus actions that are filed. Judge Frost has had, I don't want to speak for the judge, but some problems with the procedures that have been followed by DRC in regard to executions. In this one particular case, he did issue a stay on what we believe to be, we believe he was, from a constitutional point, incorrect. It was on an equal protection theory. We don't think there's precedent for that in this country, and we appealed it to the United States Supreme Court. And we do that with all great due respect to Judge Frost. We believe that we had no choice. It was something that we certainly talked a lot about for several days, but we felt we had no choice because we feel that if this decision would be upheld, and it may be, that's what the Supreme Court may do, we don't know, but if it's upheld, that we're really going to be in a morass as far as execution procedure. And the people who have to do this, Department of Rehabilitation and Corrections, Gary Moore, who heads it up, but the people who are in the execution team, a very unpleasant job, certainly not anything a lot of people are lining up to do, that what they would be facing is a shifting target, a moving target, and we would never know really what the rules were from execution to execution. And so we felt we had absolutely no choice than to appeal it to the United States Supreme Court. As far as the timing, you just don't throw these briefs together. Ours was put together within less than a week, I believe. And I think it was a very coherent brief. I'm very proud of our team to put it together. If anyone wants to see our arguments, just look at the last two paragraphs, and it's a very concise summary of what we think the constitutional issues are. Now, having said that, at the same time, the governor's office, the governor, and those around him, and Gary Moore at DRC, made it very clear to our office that they wanted to conform to what Judge Frost said. And so we have read his decision, and even though we were appealing it from a constitutional point of view, at the same time, the Department of Rehabilitation and Corrections has been working literally overtime to try to conform the procedure to conform to what Judge Frost has requested that we do. Summary is DRC's position and our position is that there is a constitutional procedure already in place. It is a good procedure, but we want to try to fine-tune it pursuant to the decision from Judge Frost. And we will do that irrespective of the final decision from the United States Supreme Court. So yesterday at 5 o'clock, I was on a conference call representing the state and with Judge Frost, and we indicated to him in the most recent or the pending execution that is was set to take place, that we did not oppose the defendant's motion for temporary restraining order, and so there would not be an execution on the date that had been set. That we acquiesced in that, did not oppose it, and assured the judge that what we were doing is trying to conform to his order. We thought we were almost all the way there, but we're not quite there. And because we were not quite there, our decision was, and the decision of the administration was, to acquiesce in the temporary restraining order.